I'd like to introduce Professor Rosa Freedman. Rosa, who is also an honorary Scot, is a Professor of Law, Conflict of Global Development at the University of Reading, and she is an expert on human rights and regularly speaks on behalf of our at the UN and has just come back from Addis. So thank you for making the effort to attend here, Rosa. Rosa has also come up as an honorary Scot and gave evidence at our census committee. So thank you very much for that too. So without any further ado, Professor Rosa Freedman.
Thank you very much to all of you for coming out. It's freezing, so I appreciate it. Thank you to the organisers for this event and for the opportunity to speak. I feel privileged and honoured to have been invited to chair a platform with these outstanding feminists to discuss the law about sex and gender, and to do so at your inaugural event. I seem to be developing quite a fondness for Edinburgh. Although I seem to spend more time on the trains getting to and from here than I do in the actual city. I want to start on a very serious note by emphasising a point that I can't emphasise enough. And this point seems to get lost or ignored, and I stood outside for 45 minutes just now with some of the people from Sisters Uncut, who I think we need to have respect for because they are young women, and young non-binary people and young trans people who care enough to do activism, and there aren't enough of those young people around. I stand for the human rights of every individual, for the fundamental rights that every person has by virtue of being born human. I will fight for those rights for all people. The rights to live free from violence and discrimination. The right to freedom of expression within lawful parameters. The right to freedom of religion or belief. The right to bodily autonomy, to sexuality, to dignity, and to many more. Everyone deserves those rights. Now, some of you, I found this really difficult to write this talk, because some people will have heard things that I've said before, or they'll have read things that I've written with Professor Rosemary Othmuti, and some people have no idea who I am. So I'm going to try and do a broad brush approach to make you all happy and probably make you all upset at the same time. In this talk, I'm going to cover some of the background on international human rights law, before turning to discuss why we have rights for vulnerable groups, what we can do where there are conflicts of rights, and what solutions we can propose to uphold the rights of all concerned. There are many legal issues to discuss, and I'm a little bit cross with two of my lawyer gender-critical friends who aren't here, because they know the national law in Scotland far better than I do, so I'm just going to avoid that. But in particular, we want to discuss the Gender Recognition Act, the Equality Act, and self-identification of gender. But before doing so, I want to take a step back and think about this issue from an international human rights law perspective. I want to explain a little bit about how international human rights law developed and the specific protection that females have under those laws, why we have those protections, and what protections sexual orientation and gender identity minorities have. Now, I use that term despite many people not liking it because that is the UN language, the language of SOGI. International human rights law sprang from the ashes of Nazi Germany. In 1945, at the end of the Second World War, it was still not unlawful in international law for Germany to have perpetrated atrocities against Jews, Roma, gays, people with disabilities, or anyone else that was a German citizen, because international law only regulated how states behaved towards citizens of other countries. So while I think we would all agree that what happened in Nazi Germany was heinous and immoral, it was not unlawful. And that's deeply problematic. I hope we all agree that that's deeply problematic. When the United Nations was created, one of the first things it did was draft the Universal Declaration of Human Rights. And the idea was to protect every individual, the weak person, against the big, powerful state. And that Universal Declaration of Human Rights says very clearly that every person is born equal and free and with dignity. And that every person, no matter what their characteristics, whether it's race, religion, social status, sex, has those rights, and has those rights in law and can be protected against their government. The problem was, and there was a lot of discussion about this at the time, ought there to be a separate treaty just for women? Because women have historically, and continue to be in many places, been subjugated, oppressed, harmed, disempowered, not only by the state, but by the societies in which they live. That question was answered in the negative, because it was felt that by separating out women from humans, that again this was a segregation, this was not a recognition that we all have these same rights by virtue of being born human. But very quickly the United Nations and countries realised that women needed specific protections to eliminate discrimination and violence against them. In 1967, the UN Commission on the Status of Women took a groundbreaking step of adopting the Declaration on the Elimination of Discrimination Against Women. That was followed in 1979 by a convention, an international treaty, and an accountability mechanism to monitor how states behave towards women. The advancement of women's rights has continued, although, as we all know, violence, discrimination, and far more are perpetrated against women all over the world at any given time. The fight for women to have specific protections has paved the way for other vulnerable groups to also do the same. The very idea of having specific protections for groups who face particular risks is no longer viewed as undermining this universal nature of human rights, but as enhancing it by saying we all have the same fundamental rights by virtue of being born human, but some people have specific vulnerabilities that mean they need additional protections, whether they are children, whether they're persons with disabilities, people from racial minorities, and so on. There's now a clear understanding that the risks that are faced by members of those groups mean that the law and practice in countries needs to protect them. Although, of course, just because we understand things and we have laws on them doesn't mean that they're being enacted. But what I tell my students all the time is that international human rights laws are there as a tool, a way for us to lobby for specific protections, a way for us to turn to our governments and say, we have these vulnerabilities, we have these rights, and you need to implement things to make life better for us. In international human rights law, the word woman has been defined as referring to biological sex. And this is similar to the law in the UK, where woman has been defined as being about chromosomes, about genitalia, and about gonads. Sorry. Always feels weird to talk to strangers about intimate details of body parts. This was the definition in various international human rights treaties and discussions, including most recently the Rome Statute, which created the International Criminal Court. And the reason that I say this is because there's a lot of talk about gender within international human rights law. But gender is very clearly defined as the oppression or subjugation of a person based on their biological sex. It's not defined as gender identity. And I think that the more that we know about this, the more tools we have to push back on this conflation of sex and gender. Gender has been defined as social constructs based on the different ways that the two sexes are viewed and treated in society. Some forms of discrimination against women might be based on their sex, so denying reproductive rights or child brides. Others may be based on gendered constructs, like denying girls the right to education because society views girls as not needing an education. The international human rights law framework and mechanisms focusing on women provide very specific protections for women, for the female sex class, to access their fundamental rights based on that long history of violence and discrimination and oppression and subjugation of women. Separately, in international human rights law, there have been some attempts to protect sexual orientation and gender identity minorities. That's the UN umbrella term for LGBT+. Almost all of those attempts are done separately to the protection of women's rights, much like the protection of children's rights will be done separately to the protection of racial minorities or people with disabilities. These are all vulnerable groups and there are no hierarchies, but they all need addressing differently because they have different needs and different vulnerabilities. The attempts to protect SOGI minorities are frequently blocked at the UN because 77 out of 193 member states still criminalise, torture, or condone violence and discrimination against LGBT minorities. And so, many of the efforts to protect those vulnerable groups have failed. Of course, we all know, I hope, that all individuals have fundamental rights by virtue of being born human, and those rights include non-discrimination and dignity. The denial of SOGI minorities to have their fundamental rights around the world is deeply concerning, and there is a long fight ahead, and a fight that I hope we will all one day join, if we're not already part of it, for those SOGI minorities to be able to live free from violence and free from discrimination and with their fundamental rights. At the international level, there were moves in the 1990s to include SOGI minorities in all the plans of actions on human rights. This was a pivotal time for human rights. The Cold War had ended, there was this great idealism, and maybe one day everyone will live with all their rights and we'll all be happy and hold hands and sing. But obviously that never happens. But the first emergence of the need to protect SOGI minorities was in the early 2000s in UN declarations and resolutions about states not doing extrajudicial killings. Basically about states not killing people because they were LGBT or T. The language then, in around 2003, was taken up in the Yogyakarta Principles in 2006. Now those principles, which lots of people bandy around, were created by a group of international human rights law experts, a self-appointed group. Those principles set out rights to which SOGI minorities ought to have and have protected. But the key issue that many people have with those principles is that they talk about self-identification of gender, not of sex, as being key to trans people being able to realise their fundamental rights. And yet that is not found anywhere else in international human rights law. There's no self-identification in terms of other vulnerabilities. There are specific definitions to decide whether or not you are a person with a disability, or you are a child, or you are a woman, and so on. A second issue that's deeply problematic is the lack of definitions of terms such as gender identity and sex characteristics, which is sort of the new terminology for genitalia. But we must remember that those principles, and the people that created them, many of whom I know and respect greatly, were aimed not at undermining women, but at kick-starting conversations and discussions around how to protect some very vulnerable people in some very vulnerable situations. It's important to remember that then and now, there's very little likelihood of creating any mechanisms to protect SOGI minorities at the international level, because those 77 countries and their allies will block them. The Yogyakarta Principles, as I said, were created by a self-selecting group of human rights experts, which is how many human rights initiatives begin, including the UN Convention Against Torture, which was kick-started by Amnesty International. But they've not been discussed by UN member states, and they've not gained any traction, which leaves them somewhat dead in the water 13 years later. They are occasionally referred to by academics. I think there was a Supreme Court case in India, although I'm not sure for the camera if that's true, that referred to them, but they are not law. They're not even soft law. They are the opinions of academics and human rights experts, much like things that I write in an academic article are opinions. You might agree with them or want to instrumentalise them or not, but they're not law. We are a broad church of women's rights activists, and I'm setting out my stall here about SOGI and international human rights law. In fact, I wrote this before the events yesterday, but I've set out my stall again today on social media. I will fight for the fundamental rights of everyone, and I will never condone violence or discrimination against anyone. Now, obviously, I think I'm right all the time. Doesn't mean that you have to think I'm right all the time. My 9-year-old says I'm wrong all the time. But that's my opinion, and I'm only offering it to you not as someone that you need to agree with, just as setting out my stall. My opinion is we need specific international human rights law mechanisms to protect any and all vulnerable groups from violations, and I believe that there are ways of doing so without undermining groups or members of other groups. Gender identity and sex are two separate things, in law and in fact. Sex has been defined and protected in law. Gender identity has not been defined and is at a very early stage in terms of any definitions and protections. Trans individuals clearly require protection, and we all ought to be concerned with the many countries where the people who do not conform to gender expectations or norms are tortured, imprisoned, forcibly sterilised or discriminated against. But those fundamental rights that all people have by virtue of being born human are one thing. protecting someone's so-called right to a gender identity goes far beyond fundamental rights, and it goes far beyond law. And if people want to protect this idea of gender identity, they need to first define it and then take it to lawmakers and policymakers to have them protect it.
Yes.
I spent considerable time listening to and reading the work of lawyers, philosophers, trans rights activists, radical feminists and many others, and I remain unconvinced, although convincible, but I remain unconvinced right now, that gender identity can be defined in a way that would be sufficient for law.
Yeah.
Sex is biological. Gender is about social constructs, and I'm yet to see a definition of gender identity that is legally robust and is not circular.
Yeah.
The idea that... I like you. The idea...
Fact-based law and subjective reality.
I like the Scots. The idea that self-identifying one's gender, and note that it's gender and not sex, has a tiny bit of support in international human rights law, not in terms of definitions, but just in terms of being referred to. The 2018 report by the UN Independent Expert on Violence and Discrimination Against SOGI Minorities defines gender identity by referring to a version of Stonewall's list of who might fall under this broad umbrella. If I go over my time, please tell me. Yep. Listing who might be a gender identity minority, including transsexuals, transvestites and non-binary, is not a definition. It's just an umbrella term and a long list. The European Court of Human Rights has stated the right to a private and family life includes something called the right to self-determine one's gender, but then haven't explained what that means. Some laws have been passed on gender identity, none of which provide definitions, and my favourite is from Massachusetts, which defines gender identity as the gender in which a person identifies. In the recent UK case of Ellen Kane last year, gender was described as a matter of self-perception when talking about how difficult it is to pin down a definition. Now, this matter of self-perception, and I'm going to name her because she's not here, is the reason that Julian Norman, who's a lawyer, talks about gender fuck. Now, she doesn't just do it because it's rude words. She doesn't just do it so my mum gets cross that I keep saying fuck on camera. It's that when you come down to self-perception, someone might feel an internal sense of self more strongly within the concept of gender fuck than other terms like genderqueer, neutrois, agender, pangender, and so on. But yet the one that's gaining traction is non-binary. And I'll quote Julian. She thinks that people use non-binary because it sounds Latin-y. Why wouldn't someone's identity as gender fucker be just as keenly felt as someone else's non-binary, if it's a matter of self-perception, which is what that UK law case said? It's pretty clear then why people seeking to protect transgender individuals' fundamental rights seek to conflate sex and gender, because there are specific protections for sex, and they need specific protections for their vulnerabilities, and it's very difficult to create them at the international or national level without definitions. Without a definition of gender identity, and in a world where trans individuals face significant human rights violations, linking gender and sex would provide a mechanism to protect their rights more robustly. But the problem is that by doing so, it would be in direct conflict with women's rights that are already established and protected in law. Individuals who are members of vulnerable groups have specific rights afforded to them based on their characteristics. Expanding the definition of a group to include others with other characteristics undermines those protections. For example, women have specific protections based on the history of discrimination and disempowerment and of male privilege being afforded to members of the other sex class. Expanding the definition of who is a woman would undermine the object and purpose of those protections. That's not to say that trans individuals don't face discrimination or abuses, but their experiences are not the same as women. They are not the same as racial minorities or persons with disabilities or any other vulnerable group. Yeah. And the experiences stem from different reasons and spaces, even if there are similarities in some of the experiences that we have. This is why it's so important to keep protecting each group according to their needs and not conflate any of them. So, let's turn to the proposed changes, and I promise I'll be done soon. In particular, I want to focus on why other countries have changed their laws and what they do in terms of conflicts of rights. 6 years ago, the UK was one of a small minority of EU countries that did not require transgender people to have forced sterilisation in order to undergo legal recognition of their preferred gender. Those countries that required forced sterilisation include Denmark, France, Italy, the Netherlands, Norway, Portugal and Sweden. Even last year, when the European Court of Human Rights ruled that forced sterilisation of transgender persons is a violation of their human rights, Belgium, Croatia, Czech Republic, Finland, Greece and Switzerland still have those laws in place. It's appalling. It is against that backdrop that we need to understand the many changes in laws on transgender individuals in many of those countries. We keep being told that those countries have self-ID without any problems, and I keep fighting back and saying that's not true. So let's start with Ireland. Until 2015, Ireland did not recognise transgenderism at all.
Yes.
And no individual could receive legal recognition of their preferred gender. Ireland now has laws that allow for self-identification of gender, including for young people, without any requirements of having had a meaningful transition or having lived for any length of time in that gender. Ireland has also retained sex-based exemptions for a large number of areas, including schools and prisons. So the self-identification of gender has very little impact on women's rights in sex-segregated spaces. The government is currently considering in Ireland whether to have specific policies on sex and gender, but currently the practice is for each institution to make its own decisions, and those decisions are protecting sex segregation where it's proportionate and legitimate. So when we hear calls in the UK to adopt self-ID just like Ireland, it would actually take trans rights backwards, given that in the UK, the GRC makes a person female for all purposes, whereas in Ireland, sex segregation remains pretty constant regardless of the GRC. In 2014, Denmark changed its laws as to how a person can change their gendered social security number. That change went from requiring medical treatment and forced sterilisation to self-ID after a 6-month waiting period, which is called a period of reflection. It also has the option for an X-gender on passports, which means that many people who identify under the broad banner of non-binary or genderfuck would be able to register in that way. There are only 6 million people in Denmark, and women's rights and the women's movement is central to that society, yet there are already cases of violence against women and rape by self-identifying women who have accessed women's spaces. And the same is true of Norway. In Malta, self-identification allows trans women to access female prisons, but the law provides for separate showers and sleeping facilities for those prisoners, and female guards are given a choice as to whether or not they search those prisoners. I'm really running out of time. But I raise all these issues because we keep being told that self-ID is fine elsewhere, but without being given the facts about what happens on the ground. And for all that people want to point to Argentina as leading the way, they conveniently ignore the fact that there are 3 prisons there. One for males, one for females, and one for all LGBTQ+ people. People point to Pakistan. Many gay individuals there are coerced into transitioning because if a person is same-sex attracted, they must be in the wrong body. And in Iran, they're not just coerced, the state forces them to transition. None of us has the answers as to what will happen, but what is clear from international human rights law is that women's rights must be protected, and that the UK has legal obligations under international human rights law to do so. In the UK, the relationship between the Gender Recognition Act and the Equality Act is such that it's unclear how these sex-segregated exemptions might be retained. Indeed, we already know that many of those exemptions are being ignored in practice, and particularly up here in Scotland since the Equality Act. What we need is clarity. Clarity in terms of law, clarity in terms of definitions, and we need proposals that will uphold the rights of all individuals, including the specific protections afforded in international human rights law to vulnerable groups. We need the UK to remember that it's party to international human rights treaties and that it is required to protect our sex-based rights.
Here.